Dear Justices of the Supreme Court of the United States. I. Dear Justices of the Supreme Court of the United States. I, Justin Riddle, come before you to petition for a writ of certiorari in a case that transcends individual grievances and strikes at the very heart of our constitutional order. At stake is nothing less than the survival of the rule of law, the integrity of our governing institutions, and the vitality of our democracy itself. Introduction. A nation betrayed, a republic in peril. As the nation watched in horror, the congressional hearings on the attempted assassination of former President Donald J. Trump laid bare a shocking reality. The very institutions charged with protecting our democracy and upholding the rule of law have themselves become vectors of lawlessness and impunity. From the stunning revelations of Secret Service misconduct and cover-up to the FBI's apparent unwillingness to hold its own accountable, the hearings painted a damning portrait of a system in crisis, a system where the most powerful among us are able to operate with virtual impunity, secure in the knowledge that the normal checks and balances of our constitutional order have been rendered toothless. With each, I don't know, I'll have to get back to you, and that's part of an ongoing investigation. Director Cheadle made abundantly clear what many Americans are only now beginning to grasp. That we now live under a regime of Byzantine UN accountability, in which the public's most basic right to honest and transparent government has been subverted at every turn by an entrenched establishment more interested in protecting its own prerogatives than in upholding its sacred duties. The searing image of the nation's top protective official blinking indifferently in the spotlight as she ducked even the most rudimentary queries into her agency's historic security collapse will forever be etched into our collective consciousness as a defining symbol of our democracy's decay. It will stand as a sickening testament to just how thoroughly the bureaucratic foxes have taken over the henhouse of popular sovereignty, and just how flippantly they now regard the proper chain of command between citizens and state. For the petitioner in this case, Justin Riddle, that portrait was all too familiar. For years, he has been caught in a Kafkaesque nightmare of official corruption and abuse of power, fighting a lonely battle to hold Nebraska state officials accountable for a litany of misdeeds and illegalities. From the Attorney General's office that published demonstrably false information about his case to the Banking Commission that turned a blind eye to clear evidence of fraud, Mr. Riddle has found himself trapped in a hall of mirrors where the very institutions meant to protect the rights of citizens have instead become agents of their subversion. Now, in the wake of the Trump assassination hearings, Mr. Riddle's personal odyssey takes on a new and disturbing significance. For what he has experienced on a personal level in Nebraska, the nation is now witnessing writ large in Washington a wholesale breakdown of the mechanisms of accountability and oversight that are supposed to keep our government honest and our liberties secure. The names and faces may be different, but the underlying pathology is the same, a system so consumed by its own institutional prerogatives and so contemptuous of the public trust that it can no longer even pretend to serve the people it is sworn to protect. This is the context in which Mr. Riddle's petition arrives at the Supreme Court not as a narrow dispute over arcane points of law, but as a clarion call for the restoration of constitutional order and the rule of law in an age of encroaching impunity. It is a plea for the court to serve as the nation's last line of defense against a rising tide of official lawlessness and UN accountability, and to reassert the primacy of the Constitution over the whims and machinations of the powerful. By taking up this case and confronting the profound issues it raises, the court has a historic opportunity to fulfill its highest calling as a check on the excesses of the political branches and a guardian of the people's fundamental rights. It has the chance to send a resounding message that in America, no one is above the law, not even those entrusted with enforcing it. And it has the power to begin the long and difficult process of restoring public faith in the integrity of our institutions and the viability of our system of self-government. This is not a responsibility to be taken lightly, nor is it one that can be met with half measures or equivocation. As the following pages will demonstrate, the rot of official impunity and the erosion of constitutional safeguards have reached a breaking point in our nation, and the court must not shrink from its duty to confront that crisis head-on. It must be willing to follow the evidence wherever it leads, and to use the full force of its moral authority and legal mandate to hold the guilty to account and to ensure that the promise of equal justice under law is more than just a hollow slogan. At the same time, this case is about more than just punishing individual wrongdoers or redressing specific grievances. It is about reaffirming the bedrock principle that in a free society, the government derives its just powers from the consent of the governed, and that when those powers are abused or perverted, it is the right and the duty of the people to hold their rulers accountable. It is about reclaiming the spirit of eternal vigilance and active citizenship that has always been the lifeblood of our democracy, and without which no Constitution or Bill of Rights can long endure. In that sense, Mr. Riddle's petition is not just a legal document, but a moral and political testament, a declaration of faith in the American creed and a summons to all those who still believe in its promise. It is a reminder that the struggle for liberty and justice is never truly won, but must be renewed and rekindled by each generation in turn. And it is a challenge to the Supreme Court to decide which side of that struggle it will be, on the side of the people and their inalienable rights, or the side of the powerful and their insatiable ambitions. These are the stakes of the case now before the court, and they could not be higher. For in an age when the very foundations of our democracy are under assault from within, the question is not whether we can afford to confront the crisis of accountability and impunity, but whether we can afford not to. The answer will determine not just the fate of one man's quest for justice, but the future of our grand experiment in self-government itself. The petitioner has done his part. He has risked everything to shine a light on the dark corners of our system and to speak truth to power, no matter the cost. Now it is up to the Supreme Court to decide whether it will heed his call and rise to the challenge of this moment, or whether it will retreat into the shadows of complicity and leave our Constitution to the mercies of those who would subvert it. Let us hope, for the sake of our republic and all that we hold dear, that it chooses the path of courage and conviction. For if it does not, the consequences will be dire not just for Mr. Riddle, but for us all. The crisis of constitutional governance. The facts of my case paint a disturbing picture of a system that has lost its way. In my efforts to participate in the oversight of Omaha public schools and previously to seek redress for the retaliatory actions of my mortgage lender, Charter West Bank, I was met with a relentless campaign of censorship, intimidation, and abuse of process by public and private actors alike who seemed more interested in preserving their own power than upholding their sworn duty to the Constitution. At every turn, I encountered a bureaucratic and judicial apparatus that was more concerned with silencing dissent and evading accountability than with uncovering the truth and serving the public interest. As I noted in my recent appearance before the Nebraska Supreme Court in Charter West Bank vs. Riddle, this pattern of unaccountable misconduct implicates every level and branch of government. When the very institutions charged with upholding the rule of law and defending the rights of the people become the instruments of suppression and the enablers of elite impunity, it represents a profound crisis of constitutional governance that goes to the very legitimacy and stability of the social contract. But as egregious as the abuses in my own case have been, they are but a microcosm of a much deeper and more insidious pattern of systemic failure, a pattern exemplified by the staggering prevalence of wrongful convictions and executions in our criminal justice system. The harrowing stories of innocent individuals like Cameron Todd Willingham, Carlos de Luna, Anthony Ray Hinton, and Paul House, who were convicted and in some cases put to death based on faulty evidence, official misconduct, and a system rigged against the marginalized and the powerless, stand as searing indictments of a legal regime that has lost sight of its most fundamental purpose, to ensure equal justice under law. In Willingham's case, for example, the forensic evidence used to convict him of arson and murder has since been thoroughly debunked by modern science, yet the courts have refused to posthumously clear his name. Similarly, in De Luna's case, the prosecution suppressed key exculpatory evidence and relied on a single, highly questionable eyewitness identification to send an innocent man to his death. These cases demonstrate the dire consequences when the legal safeguards against wrongful convictions from the right to confront witnesses to the bar on junk science in the courtroom are not rigorously enforced. The parallels between these wrongful convictions and my own Kafkaesque journey are impossible to ignore. In both instances, we see the mechanisms of accountability and oversight not just failing, but actively perpetuating injustice. We see public officials and government agencies acting with impunity, secure in the knowledge that they will never be held to account for even the most egregious abuses of power. And we see the courts, the last line of defense against governmental overreach, abdicating their sacred duty to enforce constitutional limits and safeguard individual rights. This is not just a matter of a few bad apples or isolated miscarriages of justice. It is a systemic crisis that goes to the very core of our constitutional compact. When the institutions charged with upholding the rule of law become the instruments of its subversion, when the mechanisms of accountability and redress become tools for perpetuating injustice and silencing dissent, then the very foundations of our democratic order begin to crumble. The role of the Supreme Court. This case represents a watershed moment for the Supreme Court and its role as the ultimate guardian of our constitutional order. From the seminal declaration in Marbury vs. Madison that it is the province and duty of the judicial department to say what the law is, this court has borne the sacred trust of enforcing the Constitution's constraints on governmental overreach and safeguarding the rights and liberties of the American people. But today, the court's intervention is not merely compelled by abstract principles or procedural niceties. It is demanded by the stark reality that our constitutional democracy is in crisis, that the machinery of government has become so thoroughly captured by the very forces it was meant to restrain that the rule of law itself is now in jeopardy. The record before you speaks to two inescapable truths. First, that government actors at all levels now feel empowered to weaponize their authority against dissenting voices and accountability efforts without fear of consequence. And second, that our courts have been reduced to mere procedural theater, unable to enforce the supremacy of the Constitution in the face of a system that has become institutionally incapable of policing itself. In this context, the court's duty could not be more clear or more urgent. It must rise to meet this moment with the same unflinching resolve and moral clarity that has defined its finest hours. It must reassert its authority as the ultimate check on governmental abuse and the final bulwark against the tyranny of the powerful. And it must send an unequivocal message that in America, no one, not even those who wield the awesome power of the state, is above the law. To do anything less would be to abdicate the court's most solemn responsibility and to surrender the hard-won principles of constitutional democracy to the very forces that seek to subvert them. It would be to concede that the Constitution's promises of liberty, justice, and equal protection are little more than empty words on parchment, easily trodden underfoot by those with the power and inclination to do so. A demand for constitutional accountability. That is why this petition must be understood as more than just a plea for individual redress. It is a clarion call for the court to reaffirm the most fundamental premise of our constitutional order, that ours is a government of laws, not of men, and that no person or institution is beyond the accountability and constraints that the rule of law demands. In practical terms, this means recognizing that the current standards and practices for holding government officials accountable for misconduct and constitutional violations are woefully inadequate. It means acknowledging that when core liberties like freedom of speech, the right to petition for redress, due process, and equal protection are at stake, deference must give way to searching judicial scrutiny, and official impunity must yield to the imperatives of individual rights. It means repudiating the pernicious doctrines of qualified immunity and absolute prosecutorial immunity, which have made a mockery of governmental accountability and denied countless victims of abuse their day in court. As I argued before the Nebraska Supreme Court, these doctrines effectively require plaintiffs to show that the specific facts of their case have been previously adjudicated as unconstitutional and absurd catch-22 in a world of infinite factual variation. Instead, we need a default rule of accountability for official misconduct, where the burden is on the state actor to affirmatively justify any departure from constitutional commands. It means enforcing a robust constitutional right of access to information about the conduct of public officials and agencies, so that the disinfecting sunlight of public scrutiny can penetrate even the darkest corners of our system. As the court recognized in Nixon vs. United States 1974 and U.S. vs. Nixon 1974, the constitutional presumption of transparency can only be overcome by the most compelling and particularized showing of a legitimate need for confidentiality, never as a backdoor means of inhibiting accountability or hiding misconduct. And it means making clear that those who wield the awesome powers of the state do so as fiduciaries of the public trust, bound by the most exacting standards of transparency, honesty, and fidelity to the Constitution they swear to uphold. Above all, it means anchoring our constitutional jurisprudence in the lived realities and struggles of those who are most vulnerable to governmental abuse and overreach. For far too long, the exalted rhetoric of our founding charters has coexisted uneasily with the grim facts of life for the marginalized, the dispossessed, and the disenfranchised. It is high time for the court to bridge this chasm between our nation's ideals and its practices, and to make real the promise of equal justice under law for all Americans, regardless of race, class, or social station. The chilling effects of unchecked retaliation. One of the most insidious and corrosive aspects of the systemic abuses I have experienced is the way that the very mechanisms of governmental accountability have been weaponized to silence and punish those who seek to invoke them. The experience of being victimized by a system that is supposed to protect you, and then being effectively prevented from seeking redress or accountability for that victimization, is a unique kind of powerlessness and despair. It is akin to the terror felt by a person being beaten by police who knows that any attempt to resist or defend themselves will only invite more brutality or even death. In the face of such overwhelming and unchecked power, the very act of speaking out or fighting back can seem like an invitation to even worse abuse. This is the reality faced by countless Americans who have been wronged by their government and denied any meaningful path to justice, a reality in which the pursuit of one's constitutional rights is itself treated as a punishable offense. The chilling effects of this kind of retaliation cannot be overstated. When the cost of challenging official misconduct becomes the virtual certainty of even worse mistreatment, all but the most intrepid or desperate will inevitably be deterred from doing so. And when the courts and other oversight bodies are seen as complicit in this campaign of suppression, it erodes the very foundations of public trust and institutional legitimacy on which our system of self-government depends. This is more than just a violation of due process or a miscarriage of justice in individual cases. It represents a fundamental inversion of the proper relationship between the government and the governed in a free society. When the state can act with impunity to crush those who dare to challenge its abuses, and when the courts are impotent to restrain that crushing, then the very idea of constitutional limits and individual rights becomes a hollow mockery. The Nebraska Ombudsman's Office, statutorily charged with investigating complaints against state agencies, epitomizes this inversion. As the email exchange and transcript I have provided demonstrate, this body has utterly abdicated its duty to hold government actors accountable. By refusing to engage with the substance of my complaints, fixating on procedural trivia to the exclusion of damning evidence, and ultimately retaliating against me for demanding answers, the Ombudsman's Office has made a mockery of its public trust and become complicit in the very official misconduct it is meant to prevent. When even the institutions designed to vindicate citizens' rights become instruments for suppressing dissent and immunizing lawlessness, it represents a profound crisis of constitutional governance. The Ombudsman's dereliction of duty in my case is not an isolated failure, but a canary in the coal mine signaling the systemic breakdown of checks and balances and the increasing subordination of individual rights to the prerogatives of entrenched power. The epidemic of unaccountable abuses of power I have experienced at the hands of state and corporate entities has been facilitated and exacerbated by a media and information ecosystem that has utterly abdicated its most basic watchdog responsibilities. At every turn in my efforts to expose official misconduct and demand redress, I have found myself not just unsupported but actively opposed by the very press outlets, online platforms, and political leaders whose most vital role in a functioning democracy is to hold the powerful to account. Far from isolated incidents, these experiences reflect a disturbing fusion of state, corporate, and media power arrayed against the very mechanisms of transparency and accountability they are charged with defending. The dominant players in our increasingly privatized and concentrated public sphere have become the eager accomplices of the lawless state, using their vast reach and unchecked dominion over the channels of communication to stifle dissent, steer discourse, and stonewall truth-tellers. The two tiers of American citizenship and the challenges of filing grievances compounding the injustice of retaliatory suppression is the fact that, for far too many Americans, even the purely procedural right to file grievances and seek redress against governmental misconduct is illusory. The very mechanisms that are purportedly designed to facilitate the accountability of state agencies are instead structured to insulate them from meaningful scrutiny. Consider the process of attempting to file a complaint through the official channels of the Attorney General's office. Citizens seeking to raise concerns about the conduct of state entities are directed to an online complaint system that promises a fair and accessible forum for administrative relief. Yet upon closer examination, this system reveals itself to be a bureaucratic maze that offers no clear pathway for challenging the misconduct of governmental bodies. The complaint forms provide predetermined categories for businesses, nonprofits, and other private actors, but conspicuously omit any comparable option for grievances against the state itself. This seemingly minor design choice operates as a powerful structural deterrent to official accountability, leaving citizens with no straightforward means to register their dissent and demand answers from their government. Instead, complainants are forced to navigate the more uncertain and easily ignored avenues of direct correspondence, depriving them of even the basic assurance that their concerns will be acknowledged, much less addressed. This opacity is compounded by the catch-22 I encountered between the Attorney General's complaint intake process, which offers no clear pathway to grieve governmental misconduct, and the Ombudsman's refusal to allow in-person submission of evidence, a one-two punch that effectively locks citizens out of any functional avenue for seeking redress. This amounts to a textbook case of the denial of the right to petition, a frontal assault on core First Amendment guarantees. The erosion of these fundamental freedoms is not an isolated occurrence, but part of a disturbing trend of legislative and institutional changes that have gradually chipped away at the foundations of our open society. Nowhere is this more evident than in the quiet but momentous repeal of the Smith-Mundt Act's long-standing ban on the domestic dissemination of government-produced propaganda. Passed as part of the 2012 National Defense Authorization Act, this little-noticed provision effectively legalized the use of state-sponsored misinformation and psychological manipulation against the American people, blurring the line between public relations and official deception. The result is a world in which citizens can no longer trust that the information they receive from their own government is free from political spin, selective omission, or outright falsehood. In which the very entities charged with upholding democratic transparency and accountability can legally engage in covert efforts to shape public opinion, stifle dissent, and maintain their grip on power. Adding insult to injury, the financial barriers to pursuing litigation as an alternative to these dead-end administrative channels are often prohibitive for the average citizen. The bad actors I am trying to hold accountable are keenly aware of this dynamic and are eager to exploit it, using the threat of drawn-out legal proceedings to deter all but the most privileged or persistent from seeking justice. In this way, the promise of constitutional accountability becomes a luxury good, rationed by wealth and social capital rather than guaranteed as a fundamental right. By erecting these procedural barriers, the system operates to exhaust and demoralize all but the most determined and resourceful of petitioners. It imposes a de facto tax on the exercise of fundamental constitutional rights, one that falls most heavily on those already marginalized and disempowered. And it sends a clear message that the government's accountability to its citizens is a matter of discretionary largesse rather than a democratic imperative. Such a system inverts the very notion of popular sovereignty and reduces the grand guarantees of the First Amendment to little more than empty platitudes. It is a betrayal of the animating spirit of our nation's founding, which held as sacrosanct the right of the people to petition their government for redress of grievances. And it represents a dangerous erosion of the rule of law, as it confers upon state agencies a presumptive immunity from the constitutional constraints that are meant to bind all official power. This is not the mark of a government that is truly answerable to its citizens, but rather of one that has grown too comfortable in its own impunity. It is a testament to the degree to which our legal and political order has come unmoored from its ethical foundations, and a stark reminder of the urgency of systemic reform. The imposition of financial barriers to seeking justice and accountability for governmental misconduct creates a two-tiered system of citizenship, in which the ability to vindicate one's rights becomes a function of wealth rather than a basic entitlement of personhood. This is particularly egregious in cases like this one, where the very governmental entities that have perpetrated the abuses are the ones demanding payment from their victims for the privilege of being heard. It is a form of double victimization that adds financial insult to constitutional injury, and that exposes the cruel absurdity of a system more concerned with protecting its own coffers than with delivering justice to its citizens. Access to the courts and to the levers of governmental accountability should not be a commodity to be bought and sold, but a fundamental right of every American that is essential to the health and legitimacy of our democracy. The fact that I have been forced to bear the costs of seeking to vindicate that right, after having already endured the incalculable costs of official abuse and retaliation, only underscores the backward priorities and perverse incentives of our current system. A society that makes justice a luxury good and accountability a privilege of the powerful is not one that can long endure as a functioning republic. If we are serious about the bedrock principle of equality before the law, then we must ensure that the mechanisms of legal redress and constitutional enforcement are truly accessible to all, regardless of their financial means or social status. As I noted in my appearance before the Nebraska Supreme Court, the ultimate result of this two-tiered system is that for the average citizen who finds themselves in the crosshairs of officialdom, the law is not just discretionary, it's irrelevant. When the very instruments of state power can be so easily turned against the people they are meant to serve, and when the courts offer no meaningful prospect of restraint or redress, then the social contract itself begins to unravel. The outsider's imperative. As an outsider to the legal system who has directly experienced its most grievous failures, I come before this court not just as an individual seeking redress, but as a voice for the countless others who have been silenced, marginalized, and cast aside by a system that has lost sight of its most fundamental obligations. It is precisely because of my status as an outsider that I am uniquely positioned to challenge the entrenched orthodoxies and institutional blind spots that have allowed these injustices to fester for so long. Unencumbered by the constraints of legal convention or the pressures of professional allegiance, I am free to speak the uncomfortable truths that those within the system are often unable or unwilling to confront. Indeed, history has shown time and again that it is often the outsiders, the dissidents, and the iconoclasts who are most able to see the failings of established institutions and to catalyze the transformative changes necessary to align them with our highest ideals. From the prophetic voices of the civil rights movement to the pioneering advocates for gender equality, the cause of justice has always been advanced by those willing to challenge the status quo and to demand more from our society and our institutions. Like the prophetic voices of the abolitionists and the suffragists, the labor organizers and the civil rights heroes who came before me, I understand that the arc of our republic's history has always been bent by those who dared to stand outside the citadels of orthodoxy and to call our nation back to its founding precepts. From this proud but embattled tradition of American descent, I draw my resolve to speak the uncomfortable truths that those on the inside too often cannot or will not voice. And so I come to this court not just as a litigant, but as a bearer of the stories and struggles of the multitudes who have been ill-served by the glaring hypocrisies and derelictions of our justice system. I carry with me the anguish of the wrongfully convicted, the outrage of the unjustly silenced, and the dashed hopes of all those who have learned the hard lesson that in America, the law is too often wielded as a weapon of the powerful rather than a shield for the powerless. A roadmap for constitutional accountability. As this court confronts the profound injustices and systemic failures laid bare by this case, it must also grapple with the question of how to forge a new path forward, one that reaffirms the supremacy of our Constitution and the inviolability of the rights it enshrines. While the full scope of necessary reforms may be vast, there are concrete steps this court can take to begin restoring the integrity of our institutions and the vitality of our democracy. First and foremost, the court must issue a resounding declaration that the prevailing standards for holding government officials accountable for constitutional violations are anathema to the guarantees of due process and the equal protection of the laws. It must mandate that lower courts apply searching scrutiny and robust remedies in cases involving the abuse of governmental power, with special solicitude for those violations that implicate the core liberties enshrined in the Bill of Rights. This will require, at a minimum, a dramatic curtailment of the vast extratextual immunities that have made a mockery of the notions of due process and equal protection as applied to the lived experiences of those outside the formal and informal protections of social privilege. Doctrines like qualified immunity, which effectively requires plaintiffs to show that the specific facts of their case have been previously adjudicated as unconstitutional, must give way to a default rule of accountability for official misconduct. Second, the court must put teeth into the all too often toothless mechanisms of official oversight and accountability, by declaring unequivocally that agencies like the Ombudsman's Office and the Office of the Attorney General have an affirmative and inescapable duty to investigate fully credible allegations of serious governmental wrongdoing. It must require, as a matter of constitutional due process, that victims and witnesses be given a meaningful opportunity to be heard and to challenge official accounts through an adversarial process with full access to the information and evidence needed to support their claims. This could take the form of creating independent, nonpartisan citizens' commissions to investigate and report on allegations of official misconduct, with the power to subpoena witnesses and documents, and to refer cases for prosecution where appropriate. It could also involve significantly strengthening whistleblower protections and anti-retaliation laws, to ensure that those who come forward to expose wrongdoing are not subjected to career-ending reprisals or worse. Third, the court must categorically reject the dubious doctrines of qualified immunity and absolute prosecutorial immunity, which have served for far too long as get-out-of-jail-free cards for official lawlessness and a license for abuse. It must make clear that the Constitution brooks no exemptions or escape hatches from the rule of law, and that those who violate the sacred rights of the people must be held to account in a court of justice no matter how exalted their station or formidable their power. Moreover, this court must revisit and repudiate its own past decisions that have entrenched a culture of official impunity and eroded the practical protections of our core constitutional liberties. Rulings that have barred the courthouse doors to the wrongfully convicted seeking civil redress, shielded municipalities from responsibility for their agents' misdeeds, and otherwise elevated institutional prerogatives over individual rights must be recognized as tragic missteps and reinterpreted in light of their grim real-world consequences. Fourth, the court must recognize a robust First Amendment and due process right of access to information about the conduct of the public's business, enforceable through the courts and not subject to the self-serving assertions of governmental privilege or secrecy. It must declare that the constitutional presumption of transparency can only be overcome by the most compelling and particularized showing of a legitimate need for confidentiality, and never as a backdoor means of inhibiting accountability or hiding misconduct. As the court recognized in cases like Nixon vs. United States 1974 and U.S. vs. Nixon 1974, the public's right to know must be balanced against the government's need for confidentiality in sensitive matters. But that balance must be struck through a process of case-by-case judicial review, not by a blanket deference to executive fiat or an all-purpose invocation of the state secrets privilege. Only a strong presumption of public access, enforceable through the courts, can ensure that our open society remains open and that our public officials remain accountable to the people they serve. Fifth, the court must call for the establishment of independent, nonpartisan citizens' commissions to investigate and report on the crisis of wrongful convictions in our criminal justice system, and to recommend far-reaching reforms to restore the integrity and fairness of the prosecutorial process. It must urge the states to adopt procedures to review past convictions based on discredited forensic evidence and to provide meaningful opportunities for exoneration and release for the wrongfully incarcerated. These commissions could be modeled on the successful examples of the National Commission on Forensic Science and the Innocence Commissions established in states like North Carolina and California. They would be empowered to conduct thorough, independent reviews of past cases where there is credible evidence of wrongful conviction, and to refer those cases back to the courts for further action. They could also be charged with developing new protocols and best practices to prevent future miscarriages of justice, from reforming eyewitness identification procedures to setting standards for the use of jailhouse informants and the disclosure of exculpatory evidence. Sixth, the court must use the moral authority of its bully pulpit to press Congress and the states to enact powerful new protections for whistleblowers and others who take grave personal risks to challenge official wrongdoing and expose threats to our constitutional order. It must push for a major reinvestment in the chronically underfunded and overstretched public defender system, and demand an end to the pervasive inequities that make a mockery of the ideal of equal justice under law. This could include significantly expanding the scope and strengthening the enforcement of the Whistleblower Protection Act and the False Claims Act, to ensure that those who come forward to report fraud, waste, and abuse are not subjected to retaliation or blacklisting. It could also involve a major federal initiative to provide funding and resources for state and local public defender offices, to reduce caseloads, improve training and support services, and ensure that every defendant receives the effective assistance of counsel guaranteed by the Sixth Amendment. Moreover, as a vital complement to these substantive reforms, the court must also recognize a constitutional right of citizens to record their own court proceedings and interactions with judicial officers, subject only to narrowly drawn exceptions for compelling privacy or security interests. In an era where recording technology is pervasive and where official misconduct thrives in the shadows, such a right is essential to the public's ability to hold the judicial branch accountable and to ensure that the people's courts are truly serving the people's interests. Too often, the abuses and inequities that define the day-to-day workings of our justice system are hidden from public view, with the official record controlled by the very actors whose conduct is at issue. This monopoly on the narrative of justice not only shields bad actors from accountability, but also undermines public trust and confidence in the rule of law itself. Sunlight is the best disinfectant, and the legitimacy of judicial power in a democracy depends on its continual exposure to the cleansing light of public scrutiny. A constitutional right to record, grounded in the First Amendment's safeguards for free speech, press, and petition, would be a powerful tool for unlocking the closed doors of our courthouses and letting the people see the realities of justice in action. It would also serve as a crucial check against the kind of misconduct and abuse of power that can too often flourish in the absence of independent oversight: the fabrication of evidence, the suppression of exculpatory information, the biased application of procedural rules, and the myriad other ways in which the judicial process can be perverted into an instrument of oppression. Of course, such a right would not be absolute, and would need to accommodate legitimate privacy and security concerns in sensitive cases. But the presumption must be one of maximum transparency and public access, with any exceptions narrowly drawn and rigorously justified. The people cannot meaningfully consent to the judicial power exercised in their name if they are systematically barred from witnessing its operation in practice. This case presents an opportunity for the court to take a historic step toward making the revolutionary promises of popular sovereignty and public accountability real in the context of judicial power. By recognizing a right of citizens to record their own legal proceedings, subject only to the most compelling countervailing interests, the court can help to close the gap between the stirring rhetoric of equal justice under law and the often grim realities of secrecy and impunity that confront so many Americans in their interactions with the courts. Finally, and most importantly, this court must place our nation on a permanent and proactive footing of constitutional vigilance, by declaring that the work of assuring official accountability and real-world fidelity to our founding charters is the unending obligation of every branch and level of American government. It must remind us all that the price of liberty is not just eternal vigilance against external threats, but an unflagging commitment to internal self-correction and renewal, a perpetual rededication to the hard but essential work of making our union more perfect and our justice more equal. In practical terms, this could mean establishing a permanent, independent Office of Constitutional Accountability within the federal judiciary, charged with monitoring and reporting on the state of our nation's fidelity to the rule of law and the Bill of Rights. This office would be empowered to investigate allegations of systemic constitutional violations, to issue public reports and recommendations, and to serve as a clearinghouse for best practices and a catalyst for reform across all levels and branches of government. It would serve as a kind of constitutional watchdog and ombudsman, ensuring that our governing institutions are living up to their most solemn obligations and their highest ideals. The stakes and the summons. The stakes in this case could not be higher. At its core, this is a battle for the very soul of our constitutional democracy, a fight to determine whether the principles of liberty, equality, and accountable government will endure in the face of creeping authoritarianism, or whether they will be sacrificed on the altar of governmental supremacy and institutional impunity. As the court deliberates, I ask that you consider the human toll of a system that has lost its way. I ask that you hear the anguished cries of the wrongfully convicted and executed, and that you feel the searing pain of those who have seen their most basic rights trampled by the very government that was sworn to protect them. I ask that you summon the same revolutionary spirit that animated our nation's founders as they crafted a constitution that would stand as an eternal bulwark against tyranny, and that you channel the moral courage of the American heroes who have fought and bled to perfect our union and to bend the arc of our history toward justice. But most of all, I ask that you keep faith with the sacred trust that the American people have placed in this institution as the ultimate guardian of their rights and liberties. For more than 2 centuries, generations of Americans have looked to this court as the final refuge of the oppressed and the last line of defense against governmental overreach. Through wars and depressions, through civil strife and social upheaval, the court has stood as a beacon of hope for all those who have been beaten down by the powerful and forgotten by the privileged. In its finest moments, it has been a powerful force for justice and equality, a place where the voices of the marginalized and the dispossessed could finally be heard. Today, that legacy faces its greatest test. As the winds of authoritarianism and intolerance gather on the horizon, and as the forces of division and repression threaten to tear our nation asunder, the court must once again rise to meet the challenge of its time. It must stand as an implacable foe of governmental abuse and a steadfast champion of individual rights. It must send a resounding message that in America, no one is above the law, and that the Constitution's promises of liberty, justice, and equal protection are not mere words on parchment but the living birthright of every American. This is the cause in which I now enlist the court's aid. Not for my sake alone, but for the sake of every American who has ever been victimized by a system that has lost sight of its most basic obligations. For the wrongfully convicted and the wrongfully executed, for the silenced dissenters and the forgotten victims, for all those who have been denied the full measure of their dignity and their humanity by a government that has sworn to protect them. The real prize to be won in this fateful litigation is not just the vindication of my personal grievances, but the forging of a whole new social compact between the rulers and the ruled in America. It is the chance to make the rhetorical abstractions of popular sovereignty and equal citizenship a concrete human reality for millions of our fellow citizens who have been locked out and left behind. It is the prospect of a legal order refounded on the bedrock of accountable governance, inviolate individual autonomy, and the practical enjoyment of basic rights for all persons, not just the privileged few. Such is the true promise of the cause I am submitting for this court's great adjudication, not just to undo the infuriating miscarriages of justice I have suffered personally, but to point the way toward a more authentic version of our nation's defining creeds. One that closes the gap between lofty civic preachments and lowly material conditions by using the law as a mighty leveler of the playing field. One that prioritizes the inherent dignity and infinite worth of every individual over the cold calculus of pure corporate profit or crude collective utility. One that fulfills the original populist spirit of a constitution, intended to endure for ages to come, and consequently, to be adapted to the various crises of human affairs. The imperative of constitutional renewal. That is the awesome invitation encoded in every line and lurking between every word of this petition, the chance for 9 fallible mortals in black robes to midwife the rebirth of the American Republic itself. It comes cloaked in the mundane garb of my one-man struggle against the petty tyrannies of the law and order state. But in its very particularity and granularity, in the searing first-hand intensity of its truth-telling, it opens a window onto the universal story of our unfinished revolution and frames a choice of epical stakes. Will we be a people that retreats into the fatal delusions of our cherished fables, or one that presses ahead with the unending hard work of making them real? Will our Constitution be mostly a paper museum for the edification of the elite, or a breathing testament to the power of free people to rule themselves? Will this court preside over the final defeat of the American experiment by its own internal contradictions, or will it lead the way in completing and redeeming the project of democratic self-government? These are the questions I humbly lay at your honor's feet. I ask you to see in them not just a controversy to be managed, but a calling to be fulfilled. I ask you to find reflected in my lonely ordeal a chance for collective renewal, a summons to, we the people, to at last make good on our primordial promise. And I urge you to make my case the occasion for a great jurisprudential and spiritual awakening, one that issues in a new birth of liberty under law and an emancipation proclamation for the 21st century. That is my fervent plea and my final prayer to this tribunal, offered up in the only spirit appropriate to genuine self-rule, of one free citizen to another, of one constitutional co-sovereign to another, of one member of the human family to another. For the road ahead, the gavel now passes into your hands. May you grasp it with the gravity and grace this moment demands. And may you swing it in the humble knowledge that nothing less than the survival of government of, by and for the people now rides on your deliberations and decisions. On their behalf, and on behalf of the generations of Americans yet to come, I urge the court to seize this moment and to bend the arc of history toward justice. To reaffirm the fundamental principles that define us as a nation, and to breathe new life into the eternal promise of our founding creed. That all of us are created equal, that all of us are endowed with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. Conclusion. A call to constitutional greatness. As I come to the close of my petition, I return to the awareness that I am but one broken and battered body in a nation increasingly defined by institutional violence and indifference to suffering. I know that my voice is a small one in a culture that has lost its ears for the cries of the oppressed. And I know that the forces of entrenched power and privilege will not cede their dominion without a fight. But I also know that there is great moral power in the act of bearing witness, and that no system of oppression can survive without the consent of the oppressed. By coming before this court and demanding to be heard, I am withdrawing my consent from a social order built on the destruction of bodies and the erasure of voices like mine. I am affirming the infinite worth of my one, small, human life in the face of a power structure that would reduce me to a disposable commodity. And I am claiming the right to write my own chapter in the story of America's becoming, even if my page is torn or my words are smudged with the tears of the struggle. This, in the end, is the task of every revolutionary and every reformer in every generation, to expand the frontiers of who counts as, we the people, and to make the promises of the Declaration of Independence real for those who have been shut out and left behind. It is the task that now falls to this court, as it has to the courts that came before it at every hinge point of history. It is the task of bending the arc of the moral universe a little closer to justice by asking hard questions, demanding honest answers, and being willing to follow the truth wherever it leads. May this be the court, may this be the case, and may this be the time that meets that mighty task. May it be remembered as the moment when the nation's highest tribunal stepped out of the shadow of formal law and into the light of moral reason. May it mark the beginning of a great civic reckoning and renewal, one that will echo across the generations in the lives of ordinary people finally freed to breathe the air of genuine liberty and dignity. And may it stand as a testament to the power of a single voice, crying out in the darkness, to wake a nation from its slumber and recall it to its highest self. As I stand before this court today, I am acutely aware that my ability to navigate the complex legal and institutional landscape that has been arrayed against me is in no small part due to the advent of advanced artificial intelligence tools that have empowered me to research, analyze, and advocate for my rights in ways that were once the exclusive province of the privileged few. The irony is not lost on me that it is the very system that has sought to silence and marginalize me that has, through its own excesses and dysfunctions, catalyzed the development of the technologies that are now enabling me to hold it to account. In a very real sense, the institutional forces that have railroaded me and so many others have sown the seeds of their own disruption. By exposing the depths of the rot at the core of our governing structures, they have awakened a hunger for change and a determination to remake our social contract for a new age. And by forcing citizens like myself to become reluctant legal scholars and constitutional advocates, they have unwittingly helped to birth a new generation of citizen statesmen and women, armed with the tools and the knowledge to take on the entrenched powers that have for too long wielded the law as a weapon of oppression rather than an instrument of justice. This, then, is the great paradox and the great promise of our current moment, that in seeking to crush the spirit of dissent and the quest for accountability, the enemies of democracy have instead unleashed a wave of bottom-up constitutionalism and grassroots legal innovation that threatens to sweep away the very foundations of their misrule. The introduction of advanced AI heralds a new frontier in the struggle for justice and equality under law, one in which the traditional gatekeepers of legal knowledge and expertise will no longer be able to maintain their monopoly on access to the levers of change. I come before this court not just as a petitioner seeking redress for my own grievances, but as an emissary of this emerging world of democratized justice and distributed constitutional power. My case is a microcosm of the transformative potential of these new technologies to level the playing field and give voice to the voiceless, and a harbinger of the tectonic shifts that are already beginning to reshape the very architecture of our legal system. In this brave new world, the Supreme Court will have a vital role to play in ensuring that the promise of these tools is harnessed for the cause of expanding access to justice and empowering ordinary citizens to take an active role in shaping the contours of our constitutional landscape. It will fall to this body to ensure that the AI revolution does not simply entrench existing inequities or concentrate power in the hands of a new technocratic elite, but rather that it is channeled toward the realization of a more authentically democratic and participatory vision of the rule of law. This is the great challenge and the great opportunity that lies before us, and it is one that will require a fundamental reorientation of our jurisprudence away from the hidebound formalisms and outmoded pieties of the past and toward a more dynamic, responsive, and citizen-centric conception of constitutional governance. It will require a willingness to experiment with new forms of legal process and dispute resolution, to rethink traditional notions of standing and justiciability, and to reconceive the role of the courts as not just neutral arbiters of static legal rules but as proactive facilitators of social and institutional evolution. In short, it will require nothing less than a new birth of American constitutionalism, one that is rooted in the original promise of our founding charter as a living instrument of popular self-governance but that is also responsive to the needs and the possibilities of a rapidly changing world. That is the vision that animates this petition, and the cause in which I now enlist this court's aid and leadership. May it rise to meet the summons of history, and may it help to midwife the emergence of a new era of democratic renewal and constitutional regeneration for all Americans. The road that has led me to this court's doorstep has been a long and lonely one. The abuses I have endured and the stone walls I have encountered at every turn have tested the limits of my faith in our system and my hope for redress. But they have not broken my resolve to keep fighting for the country I believe in and the rule of law I hold sacred. In this fight, I draw strength from the knowledge that I am but one in a long line of American dissenters who have struggled to hold our institutions to their own highest ideals. Like the muckrakers and labor organizers, the civil rights marchers and anti-war protesters who came before me, I know that the arc of our nation's history has always been bent by those who refused to be silenced in the face of a corrupt and recalcitrant establishment. Their courage in bearing witness until they prick the nation's conscience inspires my own persistence, no matter how daunting the road ahead. I have poured my heart and soul into this case, not for personal vindication, but for all those who have been denied the full measure of their constitutional birthright by a system that has lost its way. For the wrongfully convicted and the unjustly silenced, for those who have suffered the injury of official abuse and the insult of institutional indifference, I will continue telling my story and demanding justice, as long as I have breath in my body and fire in my belly. It is for them, and for the generations of Americans yet to come, that I submit this petition. It is for them that I ask this court to hear my plea and heed my call to renew our founding compact. And it is for them that I will keep fighting, in the fervent belief that by struggling together to make real the promise of equal justice under law, we can light the way to a more perfect union. The road that has led me to this court's doorstep is, in many ways, one that should never have been necessary to travel. In a properly functioning legal system, with real accountability for official misconduct and meaningful pathways for the redress of grievances, the systemic abuses and betrayals of the public trust that I have documented should have been addressed long before reaching this level of existential threat to our constitutional order. The fact that they have not been, that every other avenue for relief has proven to be a dead end, that every other watchdog and safeguard has been co-opted or compromised is itself the most powerful argument for why this court must now intervene in the most powerful way possible. The very existence of this petition, and the extraordinary journey of institutional failure and individual perseverance that it represents, is a testament to both the utter bankruptcy of our current system of constitutional accountability and the urgent need for a transformative reassertion of judicial supremacy to restore it. That is why, in addition to the traditional appellate arguments I have presented for why specific legal errors and doctrinal distortions must be corrected, I am also asking this court to consider the full scope of its inherent power and jurisdiction to directly confront the crisis of constitutional governance that my case embodies. Through vehicles like the writ of mandamus, the declaratory judgment, and the supervisory power, this court has the authority and, I would argue, the obligation to assert direct control over the functioning of the legal system when it has ceased to function in a manner compatible with the basic guarantees of the Constitution. Never in recent memory has that authority been more necessary or appropriate to invoke than it is today. For what my journey through the looking glass of unaccountable power has revealed is not just a series of isolated miscarriages of justice, but a fundamental breakdown of the very mechanisms of justice itself. It has exposed a rot that goes beyond any one court or agency or official, a decay at the very foundations of our constitutional order that cannot be addressed through piecemeal reforms or case-by-case error correction alone. Only a holistic and unflinching exercise of this court's supremacy over the administration of justice, guided by an unwavering commitment to the supremacy of the Constitution over all other sources of governmental authority, can begin to root out the systemic failures and structural inequities that have brought us to this point. Only a comprehensive and unapologetic assertion of judicial power to enforce constitutional limits and vindicate individual rights against the entire apparatus of the state can clear the path for a true renaissance of accountable government and public trust. This is the monumental task that I am asking the court to take up through the vehicle of my case, not just to correct the specific wrongs done to me, but to confront the much deeper and more pervasive patterns of official lawlessness and impunity that they represent. It is a task that will require the court to think and act in bold new ways, to question long-standing assumptions about the limits of its own institutional role, and to innovate new doctrinal tools and remedial frameworks adequate to the challenges of a new era of constitutional crisis. But it is also a task that is fully within this court's power and competence to accomplish. For in a very real sense, it is the reason this court exists, to serve as the ultimate guarantor of the Constitution's supremacy and the final line of defense against all forms of governmental overreach and abuse. It is the sacred charge that has been entrusted to this body by generations of Americans who have looked to the courts as the last refuge of liberty and the rule of law when all other branches and institutions have failed them. Today, that charge takes on a new urgency and a new dimension. For in an age of sprawling administrative states and privatized governance, of surveillance capitalism and platform power, the very nature of governmental authority and constitutional accountability has been radically transformed. The traditional lines between public and private, between state action and corporate prerogative, between the citizen and the consumer, have been blurred beyond recognition. And with that blurring has come a profound erosion of the basic mechanisms of democratic control and individual self-determination that are the heart of our constitutional system. If the Supreme Court is to remain true to its most fundamental purpose in this new context, if it is to preserve its role as the ultimate check on arbitrary power and the ultimate vindicator of human rights, it must adapt its jurisprudence and its jurisdiction to meet these new challenges. It must be willing to question old assumptions, to revisit settled doctrines, and to expand the boundaries of what it means to say what the law is in an era when the very meaning of law itself is increasingly up for grabs. That is the invitation and the imperative that my case presents to this court. Not just to right the specific wrongs done to me, but to use my story as a window into the much larger story of our unfinished struggle to make the promise of constitutional democracy real in a world where the forces of concentrated power and technological domination are stronger than ever. Not just to apply the law, but to redefine what the law must be if it is to remain a bulwark of human freedom and dignity in a time of tectonic change. I come before this court as a humble citizen and a proud patriot, but also as a living testament to both the resilience and the fragility of our constitutional order. My journey through the gauntlet of unaccountable power has tested the limits of what one individual can endure and still maintain faith in the system. But it has also reaffirmed my deep conviction that our founding principles and our constitutional commitments are worth fighting for, and that the fight must begin with a Supreme Court that is unafraid to lead the way. For too long, the myth of judicial restraint and institutional modesty has been used as a cover for judicial abdication and institutional complicity in the face of grave constitutional wrongs. For too long, the rhetoric of deference and neutrality has been used to mask a deeper reality of systemic bias and structural injustice. For too long, the courts have been content to stand on the sidelines as the very foundations of our democratic experiment have been eroded from within. No more. The time has come for this court to step into the breach, to reassert its most fundamental role as the guardian of our constitutional order, and to use every tool at its disposal from mandamus to declaratory relief to the full scope of its supervisory and equity powers to breathe new life into the promise of equal justice under law. The time has come for a jurisprudence of courage and conviction, one that is willing to follow the Constitution wherever it leads and to challenge entrenched power wherever it resides. This is the cause that I have come to this court to champion, and the call to action that I believe our current moment demands. It is a cause that transcends any one case or controversy, any one litigant or legal theory. It is the cause of renewing our most basic commitment as a nation, the commitment to a government of laws, not of men, to a system of justice that is truly blind and truly equal, to a society where the powerful are held to account and the powerless are lifted up. That commitment is the lodestar that has guided me through every twist and turn of my legal odyssey, and it is the North Star that I believe must guide this court as it navigates the uncharted waters of 21st century constitutionalism. For in the end, the measure of our fidelity to the Constitution is not how well we adhere to the specific contours of past precedents or settled doctrines, but how well we rise to meet the urgent challenges and transformative opportunities of our own time. My case is one such challenge and opportunity. It is a chance for this court to send a resounding message that the era of judicial passivity and institutional dereliction in the face of systemic injustice is over. It is a chance to reaffirm the supremacy of the Constitution over all other sources of governmental authority, and to reclaim the judiciary's most essential role as the ultimate check on the abuse of power. And it is a chance to light the way forward for a new generation of constitutional pioneers, who will take up the unfinished work of perfecting our union and making real the promise of liberty and justice for all. I submit this petition in the fervent hope and the unwavering conviction that this court will rise to meet that challenge, that it will seize this moment to redefine the boundaries of what is possible and what is necessary for the law to remain a living force for human liberation and social transformation. For in the end, the true test of our commitment to constitutional government is not whether we can keep the law static and settled in a world of flux and upheaval, but whether we can keep it vital and relevant in a world that is forever changing. That is the high calling and the sacred duty of this institution, as it has been since the days of John Marshall and the framers. It is a duty that I believe has never been more urgent or more necessary than it is today, as we stand on the precipice of a new era of American constitutionalism. And it is a duty that I have every faith this court will fulfill with wisdom, with courage, and with an unyielding dedication to the enduring principles of our founding charter. For in the end, the story of the Constitution is not a story of abstract doctrines or esoteric theories, but a story of flesh and blood human beings struggling to live out the true meaning of our creed. It is the story of every man and woman who has ever dared to stand up against tyranny and oppression, to speak truth to power and to demand justice in the face of overwhelming odds. It is the story of every unsung hero and every unknown patriot who has fought and bled and died to defend the sacred inheritance of liberty and self-government that is our birthright as Americans. My story is a part of that larger story, and my fight is a part of that eternal struggle. It is a struggle that I have poured my heart and soul into, not just for myself, but for all those who have been denied the full measure of their dignity and their humanity by a system that has lost sight of its most basic obligations. It is a struggle that I will continue to wage, with every ounce of strength and every fiber of my being, for as long as I draw breath. But I cannot wage it alone. No one person, no matter how determined or impassioned, can single-handedly overcome the entrenched forces of institutional inertia and official impunity that have brought us to this point. Only a movement of conscience and conviction, guided by the wisdom of our laws and the righteousness of our cause, can do that. And only a Supreme Court that is willing to lead that movement, to embrace its most expansive powers and its most solemn responsibilities, can light the way. That is the cause that I am enlisting in this court's service today, the cause of reclaiming the Constitution for all Americans, and of making real the promise of a nation where no one is above the law and everyone is entitled to the equal protection of the laws. It is a cause that I believe is worthy of this institution's highest traditions and noblest aspirations. And it is a cause that I am willing to fight for, with every tool at my disposal and every ounce of my being, for as long as it takes and whatever the cost. I can only pray that this court will join me in that fight, that it will rise to the challenge of our time, as it has risen to the challenges of times past. That it will seize this moment to reaffirm the supremacy of our Constitution and the inviolability of our rights. And that it will use this case as an opportunity to set a new standard for what it means to be a guardian of the rule of law in an age of lawless power. The stakes could not be higher, and the time for action could not be more urgent. For in the end, the true measure of our fidelity to the Constitution lies not in our ability to recite its words, but in our willingness to live out its promises. It lies in our commitment to be a nation of laws, not of men, a society where the powerful are held to account and the powerless are lifted up. A land where every man, woman, and child is treated with the dignity and respect that is their birthright as human beings and their inheritance as Americans. That is the America that I am fighting for, and that is the America that I believe this court must help to build. It will not be easy, and it will not happen overnight. But with the courage of our convictions, the power of our example, and the unwavering support of our highest court, I believe that it is an America that we can and must bring into being. The road will be long and the challenge is great. But I am ready to travel it, step by step and day by day, for as long as it takes to reach our destination. And with the help of this court, the support of my fellow citizens, and the grace of Almighty God, I know that we will get there to a new birth of freedom, a new epoch of justice, and a new era of hope for all who call this great nation home. Wherefore, petitioner respectfully requests that this honorable court 1. Recognize and reaffirm its essential constitutional role as the ultimate check on the abuse of government power and the primary guardian of individual rights, particularly in times of national crisis or institutional failure. 2. Exercise the full scope of its supervisory and remedial authority to investigate and address the systemic breakdown of accountability and the rule of law documented in this petition, and to provide guidance to lower courts and other government actors on the need for heightened scrutiny and more robust enforcement of constitutional limits in cases of official misconduct. 3. Clarify that the traditional notions of deference, restraint, and federalism that have guided this court's jurisprudence in ordinary times must give way to a more active and assertive posture of constitutional guardianship when confronted with evidence of widespread, entrenched, and coordinated assaults on the basic safeguards of our democratic system. 4. Reaffirm the fundamental principle, rooted in the Declaration of Independence and the structure of our constitutional order, that the just powers of government derive from the consent of the governed, and that when a long train of abuses and usurpations evinces a design to reduce the people to a state of submission, it is their right and their duty to alter or abolish such government and to institute new safeguards for their security and happiness. 5. Use this case as an opportunity to educate the coordinate branches and the nation as a whole on the vital importance of transparency, accountability, and the rule of law in sustaining our experiment in Republican self-government, and to enlist all Americans in the eternal vigilance and active citizenship that is the price and the promise of our constitutional liberty. 6. Grant such other and further relief as this court may deem just, proper, and necessary to vindicate the principles enshrined in our founding charters and to secure the blessings of liberty for ourselves and our posterity. I submit this petition in the spirit of that sacred civic calling, and in the fervent hope that it will be met with the same revolutionary courage and moral conviction that have defined our country's finest hours. The rest, as always, is in the hands of history and in the hearts of those entrusted to be its conscious agents on this Supreme Court. In the final analysis, the true significance of this petition lies not just in the specific relief it seeks from this court, but in the broader spirit of democratic renewal and constitutional recommitment it aims to awaken in the American people as a whole. For while the opinion of the Supreme Court will carry enormous legal and symbolic weight, the ultimate fate of our republic rests with each of us and our willingness to fight for it. The change we need cannot come from any one lawsuit or any one leader, but must arise from a mass movement of ordinary citizens reclaiming our birthright of self-governance and constitutional guardianship. So let this filing be a beginning, not an end, the spark that ignites a new era of popular sovereignty, institutional accountability, and grassroots constitutionalism in America. Let it stand as an invitation to every citizen who still believes in the revolutionary promise of our founding ideals to take up the torch of eternal vigilance and active civic engagement. From the halls of power to the streets of our communities, we must all become citizen sentinels and citizen statesmen, working tirelessly to make real the audacious promises of our national charter. We must be the heirs to Jefferson and Madison, to Douglas and Lincoln, to King and Kennedy, the new generation of Americans who will finish the unfinished work of forming a more perfect union, block by block and case by case. This is the sacred calling that I have tried to answer with this petition, and that I now pass on to my fellow citizens is the great and grave responsibility of our time. For in the end, it is not any one legal argument or judicial decree that will save our constitutional order, but the collective power of we the people to rise up and revitalize it from the ground up. So let us go forward from this moment committed to that revolutionary renewal, in our courts and in our country. Let us reclaim the mantle of popular constitutionalism and democratic self-determination that is our rightful inheritance. And let us rededicate ourselves to the eternal American project of making liberty and justice for all not just a noble aspiration, but a lived reality. The road ahead will be long and the challenge is great. But I have seen the indomitable spirit of American patriotism and democratic faith embodied in the struggles of countless unsung heroes across our land. I know that we as a people are equal to this moment if only we can summon the courage to seize it. The Supreme Court must do its part by meeting this petition with the same boldness and moral conviction with which it was written. But the rest is up to us. The history of American freedom is ours to write in this hour of maximum danger and maximum opportunity for our republic. So let us go forward to vindicate the Constitution, not just in our laws but in our lives, to be the change that we wish to see in our system of government and in our society as a whole. If we can rise to that challenge, as generations of Americans before us have in their hours of trial, then I have no doubt that the promise of this petition will be realized and the dream of a government truly of, by and for the people will never perish from the earth. Respectfully submitted. Justin Riddle. Citizen, patriot, and believer in the American promise.